So, so today we discuss this polity questions about citizenship, union territory, and election machinery. Some of the miscellaneous areas which UPSC will give substantial importance. So, to start with, citizenship in India is governed by one constitution or two law. So, among the options given, one and two, one only, two only, none of the above. So citizenship in India is governed by both the provisions of constitution as well as the legislation. Constitution Article 5 to 11 in the part 2 and the Article 11 says that Parliament can enact a law to determine the legal provisions of the citizenship. So accordingly, in 1955, Citizenship Act was enacted, of course, which was amended in 1986, 1992, 2003, 2005, 2015, and also in 2019. So this 2019 amendment is the most controversial one, the details about which we have already discussed. So answer for this first question is A, both 1 and 2. It is determined by the constitutional provisions as well as the law. The law is Citizenship Act 1955. Second question, how a person can become a citizen of India? Jus sanguinis and jus soli. Is it both or only one or only two or none of the above? So here these terms jus sanguinis and jus soli, these terms are Latin words. Jus sanguinis means citizenship by nature, that is the natural citizenship, so which is by birth or by blood relationship. Jus soli is a naturalized citizenship. That is, you can acquire the citizenship of India by registration. So in India, the constitution is allowing both jus sanguinis and the jus soli method. So answer is both 1 and 2. For question number 2, its answer is A. Third question, persons domiciled in the territory of India as on 26 November 1949, 1. Automatically become the citizens of India by virtue of operation of the relevant provisions of the Indian Constitution, were required to be registered as the citizens before 1950 January 26 if they were the Europeans. So both the statements are correct, subject to the provisions of Constitution. So question number 3, answer is A. Question number 4. Any person born in India on or after 26 January 1950 but prior to the commencement of 1986 Act on July 1st, 1987 is a citizen of India by birth. A person who is born in India on or after 1st July 1987 is a citizen of India if either of the parent is a citizen of India at the time of the birth. So when either of the parent means either it can be the mother or the father. Third, those born in India on or after 3rd December 2004 are considered citizens of India only if both of their parents are citizens of India, or if one parent is a citizen of India and the other is not an illegal migrant at the time of the birth. 4. A birth certificate, passport, or even an Aadhaar card alone may not be enough to prove the Indian citizenship unless the parents are Indian citizens. So this point number 4 in the options is given by this Bombay High Court. You can make note down, that is Bombay High Court has given this provision number 4 in a judgment in 2013. So therefore, all the 4 statements are correct. Question number 4, answer is A. So the provisions of citizenship are guided not only by the constitutional provisions, but also by the law as well as the interpretation of the constitution as well as the law as interpreted by the judiciary from time to time. Question number 5. Persons born outside India on or after 26 January 1950 but before 10th December 1992 are citizens of India by descent. And there are some conditions about it. That is, if their father was a citizen of India at the time of birth, if either of the parent was a citizen of India at the time of birth, if either of the parent was a registered citizen in India at the time of birth. D, none of the above. So in the earlier 1986 amendment, it was said that uh, if either of the parent was a citizen of India, citizenship can be acquired. But if the person born outside India after 26 January 1950, before 10 December 1992, this amendment has suggested that if the father is a citizen of India, only the father has to be a citizen of India, right? Not either of the parent. So the answer is A. Oh, for question number 5. A is the answer. Question number 6. Persons born outside India on or after 10th December are considered as citizens of India if either of the parents is a citizen of India at the time of their birth, if the father was a citizen of India at the time of the birth. A or B, D, neither. So if a person who is born outside India on or after 10 December is considered as a citizen of India if either of the parents is a citizen of India at the time of the birth. A is the answer for question number 6. 6A, not A or B. 7. Question number 7. From 3rd December 2004 onwards, persons born outside of India shall not be considered citizens of India unless their birth is registered at an Indian diplomatic mission within the period of 1 year of the date of birth. So answer for the question number 7, 7A. In certain circumstances, it is possible to register after 1 year, but not in all the circumstances, with the permission of the central government. The application for the registration of the birth of a child must be made to an Indian diplomatic mission and must be accompanied by an undertaking in writing from the parents of the child. So question number 8. So question number 7, answer A. I have typed it in the live chat also. Question number 8. Central government may on an application register as a citizen of India under section 5 of the Citizenship Act 1955 any person not being an illegal migrant if he belongs to any of the following categories. A person of Indian origin who is ordinarily resident of India for 7 years before making the application. So under section 5(1)(a), so throughout the period of 12 months immediately before making application and for 6 years in the aggregate in 8 years period. Second, a person of Indian origin who is ordinarily resident of any country or place outside undivided India. A person who is married to a citizen of India and is ordinarily resident in India for 7 years before making an application for registration. 4. Minor children of persons who are citizens of India. So all the 4 conditions means question number 8 is D. Answer to question number 8, D. Question number 9. Citizenship of India by naturalization can be acquired by a foreigner, not an illegal migrant. Illegal migrant is the one who has entered India without the necessary documentation. Or the person who has entered with the legal documentation but has stayed in India beyond a specified period in the visa is an illegal migrant. So this is asking only about the foreigner who is ordinarily resident in India for 12 years throughout the period of 12 months immediately preceding the date of application, for 11 years in the aggregate in the 14 years period preceding the 12 months. So answer for this question is A. All the three statements are correct for the ninth question. Rahul Gandhi is going to marry an Italian girl. It is only an assumption, not a truth. If she has to get the citizenship of India, how many minimum years that she should reside in the country? So should it be 5 years, 7 years? There is no such minimum residence are required if the citizenship is acquired by the marital relationship. Wife of Rahul Gandhi don't need minimum requirements to get the Indian citizenship. So answer for this question is 5 years. Anybody who wanted to get the citizenship of India by matrimonial relationship uh, is the citizenship requirement is 5 years minimum. So question number 10, answer is A. 11. Citizenship can be deprived by a compulsory termination under the following conditions. So in India, the Citizenship Act is not only providing for how to get the citizenship of India, it is also providing for how the citizenship is deprived. అంటే సిటిజన్షిప్ ఏ విధంగా పొందడం కాదు, పొందడంతో పాటు ఎలా పోతుంది అనేది కూడా చెప్పడం జరిగింది. సిటిజన్షిప్ పోవడం అంటే ఎలాంటి కండిషన్స్ ఉంటాయి. సిటిజన్స్ has obtained the citizenship by fraud. 2. Citizens have shown disloyalty to the Constitution of India. The citizen has unlawfully traded or communicated with the enemy during the war. The citizen has been ordinarily resident of India for 7 years. So this is the citizenship can be deprived by a compulsory termination under the circumstances like citizen has obtained the citizenship by fraud. Anybody, the citizen who has shown disloyalty to the Constitution of India. The citizen has unlawfully traded or communicated with the enemy during the particular period. The citizen has been ordinarily resident of India for 7 years. So the answer for this should be 1, 2, and 3 because 4 is not the actual factor. So answer from among the given options, there is no answer. So answer should be 1, 2, and 3 only. 12. Question number 12. According to the Constitution, which of the following categories of persons became the citizen of India at the commencement of the Constitution? Persons domiciled in India, persons who migrated from Pakistan, the persons migrated to Pakistan but later returned, the persons of Indian origin residing outside India. So all this, among these 4, 1, 2, and 3 are correct. Not the fourth one, 1, 2, and 3 only. So 12, question number 12, B is the answer. Question number 13, notwithstanding anything in Article 5, any person who or either of whose parents or any of whose grandparents was born in India as defined in the Government of India Act 1935 and who is ordinarily residing in any country outside India as so defined shall be deemed to be a citizen of India if he been registered as a citizen of India by the diplomatic or consular representative of India in the country where he is for the time being residing on an application made by him, therefore to such diplomatic or consular representative, whether before or after the commencement of this Constitution, in the form and manner prescribed by the government of the Dominion of India, of the Government of India. So this is the entire description under Article 5 of the Constitution. So which of the following conclusions can be drawn from this provision provided under Article 8 of the Constitution? This is the entire description is provided in the Article 8. So what conclusion can be derived from this paragraph? For question number 13. Rights of citizenship of certain persons who have migrated to India from Pakistan. This option A is under Article 6, not 8. Rights of citizenship of certain migrants to Pakistan. The option B is under Article 7 of the Constitution. You can note down over there. A is in the Article 6 and B is under Article 7. C. Rights of citizenship of certain persons of Indian origin residing outside India. This is under Article 8. So answer is C. And D is persons voluntarily acquiring the citizenship of a foreign state not to be the citizens. E is mentioned in the Article 9 of the Constitution. So question number 13, answer C. Question number 14, statement. Every person who is or is deemed to be a citizen of India under any of the provisions of the Part 2 shall, subject to the provisions of any law that may be made by the Parliament, continue to be such citizen, as mentioned in the Article 10. The statement is mentioned in the Article 10. Which of the following conclusions will follow the statement? Conclusion 1. Parliament can regulate the right of citizenship. Conclusion 2. There shall be a continuance of the rights of the citizenship. So this statement in the question number 14 is saying that Parliament can enact a law for regulating the provisions of citizenship as mentioned in the Article 11. So only one follows, not both, only one follow. So that means question number 14, answer B. Which of the following will not be deprived of having the privilege to enjoy? Article 15, 16 and 19. Will not be deprived. The question is saying will not be deprived of having the privilege to enjoy the Article 15, 16, 19. అంటే ఆర్టికల్ 15, 16, 19 ద్వారా వచ్చే హక్కులు ఎవరికి ఉండవు, ఎవరికి మినహాయించలేము అన్నట్టు. అంటే సిటిజన్స్, సబ్జెక్ట్స్, ఏలియన్స్, ఏ అండ్ బి అన్న. అంటే 15, 16 అండ్ 19 ఇవేంటివి? 15 అనేది ప్రొహిబిషన్ ఆఫ్ డిస్క్రిమినేషన్, అంటే వివక్షతలు నిషేధించడం. 16 అనేది ఈక్వల్ ఆపర్చునిటీస్ ఇన్ మ్యాటర్స్ ఆఫ్ ఎంప్లాయ్మెంట్, ప్రభుత్వ ఉద్యోగాలు అందరికీ సమానంగా ఉంటాయని చెప్పడం. Article 19 is about 6 freedoms. So these 3 freedoms can be excluded to the aliens who are not the citizens of India. Will not be deprived annappudu meaning citizens, they cannot be deprived to the citizens. So answer for question number 15 is A. 16. What is true about the PIO card? Persons of Indian origin. It used to be given to all the persons of Indian origin living in the country, in the world. Living in any country in the world. Of course, except Afghanistan, Bangladesh, Bhutan, China, Nepal, Pakistan and Sri Lanka. Other than these countries, remaining other people in the rest of the world, in any country, would be given this, or probably given these opportunities to enjoy the PIO card. OCI card is merged with the PIO card. On 9th January 2015, the persons of Indian origin card scheme was withdrawn by the government of India and was merged with the overseas Indian citizens of India card. So the answer is only 2. C is correct. 16C. Every 17th question, every union territory shall be administered by the president, administrator, governor of an adjoining state, lieutenant governor. So though subjects in the previous question means the people of a country who are ruled by a foreign government, something like the Indians who were ruled by the British government. So when the British were ruling the country, the people of India were the subjects. Aliens are completely foreigners who are residing in the country. So question number 17, every union territory shall be administered by the president on behalf The president, there may be an administrator or a lieutenant governor. So, according to Article 239, uh, the union territory shall be under the administration of the president, on whose behalf lieutenant governor and an administrator may be administering the nation, administering the union territory. So, question number 17, answer A. 18. Who can create a legislature for a union territory? For a state government, legislature is created by the constitution itself. Uh, for a union territory, legislature shall be created by the parliament. So it's right question. For 18, it is B. Question number 19. What is true about the National Capital Territory of Delhi? It was it was a special status. It has a special status by the 69th Amendment Act 1991. The administrator is called Lieutenant Governor. The provisions of Article 324 to 327 and 329 shall also apply to the Union Territory. So all the three provisions are correct. For question number 19, A. So originally, Delhi was only a Union Territory, and in 1991, by the 69th Amendment, it was made as a National Capital Territory with a partial status of a state, not a complete status of a state. Now the Delhi is demanding for a full status of a state. Delhi Legislative Assembly enact the laws on state list, concurrent list, and the union list. So 1, 2, 3 or 1 and 2, 1 and 3 are none of the above. So Delhi Legislative Assembly, like any other state legislature, can make the laws on state list as well as concurrent list. The మిగతా స్టేట్స్లో కూడా ఏ విధంగా అయితే అసెంబ్లీస్ రాష్ట్ర జాబితా మీద ఉమ్మడి జాబితా మీద చట్టం చేయడం జరుగుతుందో అదేవిధంగా ఢిల్లీ లెజిస్లేటివ్ అసెంబ్లీ కూడా రాష్ట్ర జాబితా మీద ఉమ్మడి జాబితా మీద కూడా చట్టం చేయొచ్చు. స్టేట్ లైక్ ఎనీ అదర్ స్టేట్, ఢిల్లీ లెజిస్లేటివ్ అసెంబ్లీ కెన్ మేక్ ద లాస్ ఆన్ బోత్ స్టేట్ లిస్ట్ as well as concurrent list. So answer for question number 20 is B. Chief Minister of Delhi National Capital Territory shall be appointed by the President, Governor, Lieutenant Governor, or Lieutenant Governor in consultation with the President. So recently Delhi's elections were held, and after the election, the President has appointed the Chief Minister of the Delhi Assembly. Can they make laws on police and forest? Police is in the central government control in the Union Territory. Forest is in the concurrent list, and there is no forest region in the Delhi region. So 21, the President shall appoint the Chief Minister of Union Territory of Delhi. So it is only for Delhi, they are not applicable to the remaining. Administrator is different, Chief Minister is different. Administrator will be like for Delhi there is no administrator. For Delhi, Lieutenant Governor will be there. Lieutenant Governor will be advised by the Chief Minister, but CM is appointed by the President only. The situation in Pondicherry is different. Who may constitute High Court for the Union Territory? It is only the Parliament can constitute the High Court for Union Territory. Parliament can make the laws for the state of Jammu and Kashmir with reference to question number 23. The nature of provisions under Article 370, which is repealed now, that implies that 23 is temporary transitional provision, not a permanent provision. So answer is A for 23. 24. Parliament can make the laws for the state of Jammu and Kashmir with reference to the union list, concurrent list, as well as the state list. So on all the three items that the Jammu Kashmir areas, the Jammu and Kashmir related areas can be enacted by the Parliament in the present form, because in the original form, Parliament can make the laws only with reference to the Union and concurrent list with reference to Jammu and Kashmir. But after the repealing of Article 370, repealing the special status of Jammu and Kashmir, the answer stands D, 24D. That is, the Union Parliament has possibility to make the laws on the Union list, state list, as well as concurrent list. So 24D. Which of the following apply to the state of Jammu and Kashmir? So Article 238 stands repealed, because it was repealed in 1956. It contained 238 contained second category states. So therefore, since 238 is being repealed, there is no applicability of Article 238. Article 1 is about India, that is Bharat, is a union of states. So including Jammu and Kashmir stands now. Then Article 370 is not repealed yet. Only special status in the Constitution, Article 370, continue to exist. The special status given to the Jammu and Kashmir under Article 35A, which was invisible earlier also, has been repealed. So 2 and 3 is the answer for question number 25. The correct statement is for question number 26. The official language of the Union shall be Hindi in Devanagari script. The form of numerals to be used for the official purposes of the Union shall be the international. The English language shall continue to be used for all the official purposes of the Union for which it was being used immediately before such commencement. So it is అంటే తెలుగులో దీన్ని చెప్పాలంటే ఇంగ్లీష్ భాష భారత రాజ్యాంగం అమల్లోకి వచ్చిన ఎంతకాలం వరకు అధికారిక భాషగా ఉంటుంది అని చెప్పి ఇక్కడ క్వశ్చన్ చెప్తున్నారు. సో క్వశ్చన్ నెంబర్ 27కి 15 ఇయర్స్ ఆన్సర్. అంటే 15 ఇయర్స్ అంటే సి ఇస్ ది ఆన్సర్ ఫర్ క్వశ్చన్ నెంబర్ 27, సి. For up to 15 years, thereafter it can be extended beyond 15 years every time by enacting the amendment to the Constitution. Question number 28. Commission and Committee of Parliament on Official Language shall be constituted by the President, Parliament, Speaker of Lok Sabha, Chairman of Rajya Sabha. So according to Article 344, there is a provision for the Commission on Official Language with 30 members in the Lok Sabha, 20 members in the Rajya Sabha. The total members is 30. Lok Sabha representing 20 and Rajya Sabha representing 10. So 28 is A. The President will constitute this commission on official language. '26 answer is A. It has already been uploaded. Commission 28 is A, the President. 29th, Commission and Committee of Parliament on Official Language shall be responsible to recommend the President on all the 4 areas, on all the 5 areas, which is being mentioned over here, regarding the progressive use of Hindi language, restrictions on the use of English language, language to be used for all or any of the purposes of Article 348, form of numerals to be adopted, and anything. So 29 is A. The Commission and Committee of Parliament on Official Language, in making its recommendation, shall have due regard to industrial, cultural, scientific, and advancement of India, the just claims and the interests of persons belonging to the non-Hindi speaking people. So both are to be considered by the Parliament by this commission in making its recommendation to the President. So question number 30, answer is A. 31. Official language of Supreme Court and High Courts and the laws enacted by the Parliament and which ordinance shall be in the which language? English, Hindi, or both? None of them. The official language of Supreme Court shall always be English only, not Hindi. Supreme Court judgments will be given only in the Hindi language. And the laws enacted by the Parliament also, the Parliament may convert them into Hindi translation as well. So 31A, 32. Which of the following are the provisions for linguistic minorities? Providing primary education in mother tongue. That is, the state has to provide primary education to the children of minorities in their mother tongue. There shall be a special officer for the linguistic minorities to be appointed by the president. Discretion for the development of Hindi. So, so there is no discretion. It is a compulsion, a directive. So 1 and 2 are correct. So our question number 32, answer is B, because linguistic minorities are given provisions only for two things, 1 and 2 only. Then there are some questions about the elections. Question number 33. Elections in India are regulated by Constitution under Article 324 to 327. Statutes, various legislations regarding the regulation of the elections, including the Representation of Peoples Act and Representation of Peoples Act of 1950 and Representation of Peoples Act of 1951, Election of President and Vice President Act 1952. So there are three legislations which are regulating the elections in India. So answer is A for question number 33. What is the minimum age to contest elections in India? So is anyone answering this question? Let's see. A logical question. What is the minimum age to contest the elections in India? I'm asking you to post the answer for this question, number 34, before me answering, because it's just a logical question. By looking at it, you can answer this question. 21 years is the minimum age for the Panchayat Raj. Ikit Reddy has given the reasoning also. For panchayats and the local bodies, the minimum age to contest the election is 21. Lok Sabha and Vidhan Sabha, it is 25. Rajya Sabha and Legislative Council, it is 30 years. President and Vice President, it is 35 years. So the minimum age to contest the election in India is 21 years. Answer is A. 35. Decisions in the Election Commission are based on, is also a simple logical question. Consensus or majority or unilateral decision making or secret ballot. So till 1989, Election Commission was a single member body, so therefore its decisions were unilateral since it is a single member body. But after making it as a multi-member body, a three-member body, the decisions are based on the majority, not consensus. There cannot be any consensus as such. So if the two other members of the Election Commission decides, they can override even the opinion of the Chief Election Commissioner. So answer for question number 35 is B, majority principle. Question number 36. A member of Legislative Assembly can vote in which of the following elections? So this question number 36 require a comprehensive understanding, not a memory or anything else. A Legislative Assembly member can vote for Lok Sabha, Vidhan Sabha, Vidhan Parishad, President or Vice President. So who will answer? Let me see for question number 36, who is going to answer first? It's a logical question, just a thinking question, and need an understanding. Question number 36, who is answering? Let me see. Likit Reddy given an answer D, is excluding Vice President. And any other? 36A, Shah Wali Chauhan uh, imposing all the above. But as I told you several times, all the above is sometimes is not correct. So answer for this question is D, because uh, Legislative Assembly member, the Vidhan Sabha member can vote in any elections, local body election, Lok Sabha election, Vidhan Sabha election, and also Vidhan Parishad election. If he is a member of, if he is a graduate, he can vote for the graduate constituency. If he is, and he is also eligible to vote for the Vidhan Parishad from the MLA constituency, and for the presidential election also, but not for the election of vice president, because the election of vice president will be participated only by the members of Lok Sabha and the Rajya Sabha. So 36 is D. Only 1, 2, 3, 4, but not 5. Question number 37. The Election Commission transacts its business by holding regular meetings, by circulation of papers, by delegation of powers. So it's an administrative question. So answer to question number 37 is A. 38. Which of the following statements are correct? Chief Election Commissioner can veto the decisions of the rest of the two members. I think I given this answer in an earlier question. So Election Commission takes the decision by majority. So the remaining two commissioners can override the CEC decision, but not CEC can veto the decision of the two members. So A is wrong. Decision of the CEC can be vetoed by the remaining two members. All the three election commissioners have equal say in the decision making of the commission. So answer, as I told you, is B. The decision of the CEC can be vetoed by the remaining two members by majority principle. So answer 38 is B. Question number 39. All the state level election, at the state level, election work is supervised subjected to overall superintendent direction and control of the commission by the chief electoral officer of the state. What is true about this? He is appointed by the commission from among the senior civil servants. He is proposed by the concerned state government. He is in most of the states a full-time officer and has a small team of supporting staff. All the three conditions are correct. A is the answer for question number 39. Question number 40. Which of the following interventions are barred in the election work of any sort? The meaning of the question is, the ఈ ఎన్నికల సంఘం చేసే పనిలో ఎవరు జోక్యం చేసుకోకూడదు. Who cannot interfere in the work of the election commission. Now, once the electoral process begins, executive cannot interfere and judiciary cannot interfere. Judiciary cannot interfere by virtue of Article 329, and executive cannot interfere by virtue of the election code. But Parliament by a law can regulate the elections. So answer is 1 and 3 for question number 40. It is D. State Election Commission conducts the elections of. This should be answered because it is very much in the news. No, in the recent times in the Andhra Pradesh, State Election Commission conducts the elections only of municipalities and panchayats as well as cooperative societies. 2, 3, and 4. B is the answer. So question number 41, B. So state legislature election will be conducted by the National Election Commission. 42. Which of the following are true about the cooperative societies? A chapter on cooperative societies was inserted by the 97th Amendment in 2012. It is wrong because it is incorporated in 2011. So Sana is asking a question. What is the difference between A and B sentences in question number 38? Let me go back. Chief Election Commissioner can veto the decisions of the rest of the two. Decision of the CEC can be vetoed by the remaining 2%. They are contradicted. They are opposite statements. CEC turning down the opinion of the two members is not possible because the decision will be made on the majority. Decision of the CEC, Chief Election Commissioner, can be vetoed by the remaining two members. If the decision is taken by a majority, the two members can take one opinion. The remaining is the Chief Election Commissioner. So answer B for question number 38. And coming to question number 42 back. Which of the following are true about this cooperative societies? A chapter on cooperative societies was inserted by 97th Amendment, but not in 2012. It was in 2011. Article 243ZH, 243ZU deals with the affairs of the cooperative societies. It is not U, up to 243ZT, not U. 3. Governor make provisions for the incorporation of regulation and winding up of cooperatives. It is done by state legislature, not the governor. You can make the rectification. 4. Number of directors in the board of society shall be determined by the state legislature subject to maximum of 21, not 20. So question number 42 is D. None of the above is correct. None of the above are true because in the statement 1, there should be 2011, not 2012. Statement 2, there should be 243 ZU, ZT in place of ZU. Statement number 3, governor should be replaced with state legislature. Statement number 4, number of directors is not 20 maximum, it should be 21. Answer issues is asking, please explain 40. What is 40? Which of the following interventions are barred in the election work of any sort? Meaning, once the election work started by the election commission of any type, who cannot interfere in the election commission's work? Executive, legislature, judiciary. So once the election work has begun, executive cannot interfere because there is a election code. అంటే ఎన్నికల కోడ్ ఉంటుంది కాబట్టి ఎన్నికల సంఘం వ్యవహారాల్లో ఎగ్జిక్యూటివ్ ఇంటర్ఫియర్ కాకూడదు. జ్యుడిషియల్ ఇంటర్ఫియర్ కాకూడదు ఎందుకంటే ఆర్టికల్ 329 ప్రకారం ఎన్నికల పని ముగిసేంత వరకు కూడా జ్యుడిషియరీ కూడా ఇంటర్ఫియర్ కాకూడదు. సో ఆర్టికల్ 329లో ఈ అంశం చెప్పబడింది. 1 and 3 are correct. So question number 43 is none of the above. D is the answer. 42, D is the answer. 43. Cooperatives are under which list? Union list, state list, or concurrent list? So question number 43 is a direct question. Development of cooperatives is the responsibilities of the state government as mentioned in the directive principles also. So 43 is B. 44. Which of the following are true? Registration of political parties is done by the election commission after the election. So registration should be done before the election. A political party has to register itself with its name and members and the president. B. Second, recognition of political parties is granted by the election commission within 6 months of their formation. So recognition is given as a regional party or a national party. That recognition will be given after the election, not before the formation, before the election. So the explanation of registration is in the 2, recognition in the 1. Third, registration and recognition of political parties is a quasi-judicial function of the election commission. Very true. It may give or may not give. So it decides by its own. 4, decisions of the election commission can be challenged in the high courts and Supreme Court. So the decisions of the election commission regarding the assembly and parliament election are challenged in the high court. Decision of the Election Commission regarding the election of President and Vice President will be challenged in the Supreme Court. So 3 and 4 only are correct for question number 44C. 45. Voter participation in the democratic and electoral process is integral to the successful running of any democracy and the very basis of wholesome democratic elections. Recognizing this, Election Commission of India formally adopted voter education and electoral participation as an integral part of the election movement management from the year 2009. A straight question. 45, question number 45, B is the answer. Question number 46. Which of the following are celebrated by the Election Commission to showcase India as a vibrant and performing democracy? The event that include a photo exhibition capturing some special moments from the beginning of general elections and queries on registration and voting will be answered and the electoral process explained at a model of a polling station and facilitation center. సో ఎలక్షన్ కమిషన్ సెలబ్రేషన్ చేసేటటువంటి ఒక యాక్టివిటీ ఏంటంటే మతదాత మహోత్సవ్ అంటే ఓటర్ డే. మతదాత మహోత్సవ్ అంటే ఓటర్స్ డే celebrated on January 25th. January 25th is the formation day of Election Commission. Question number 46B. 47. In which of the following provisions reference of the language is found? Eighth schedule consists of the list of 22 recognized languages. Part 17 consists of Article 343 to 351 and Part 3. Part 3 is about the fundamental rights. Can anyone give the answer for this question? So does fundamental rights have a provision for the language or not? Are there any fundamental right which talks about the provisions of language? Let me see who will answer. Under which provision that there is a provision about the language in the fundamental rights? The Article 29 is talking about the linguistic aspects of the fundamental rights related to the minorities. The Article 29. So therefore, all the four are correct. For our question number 47, it's A. So linguistic minorities are of two types: linguistic minorities and religious minorities. So the minorities who are either linguistic or religious minorities can have their own educational institutions. Question number 48. A state can have English as the official language, more than one language as the official language, Hindi as the official language. So can you give the answer for this? A state can have English as the official language, more than one language as the official language, or Hindi as the official language. 48 question number. So a state can have Hindi also as an official language. Suppose Madhya Pradesh, Uttar Pradesh, English official language is there for almost 10 states in the country. And multiple official languages are there for at least 8 to 9 states in the country. So 48A. 49. What is true about presidential election? Independent candidates cannot contest. So let me see who will answer this. So question number 48. A state can have Hindi as official language. Of course, not mandatory. It is an option. It may have or may not have. So 48A, 49. What is true about the presidential election? Let me see who is going to answer this first. Independent candidates cannot contest. Presidential election is held at a national level. Voters require minimum knowledge of reading and writing. Party whip is not applicable. So, do you think that the voters need to have a reading and writing knowledge? No, definitely they need to have a reading and writing knowledge because of the uh, single transferable system where the voters have to read the names of the contestants. అంటే ఈ బ్యాలెట్ పేపర్ మీద ఉన్న వాళ్ళ పేర్లు చదవాలి. అలాగే చదివిన తర్వాత వాళ్ళు ప్రయారిటీ ప్రకారం ఓట్ వేయాలి. కాబట్టి రాయడం రావాలి. And it is party whip is also not applicable, which is applicable under the anti-defection law. So therefore, answer for this is independent candidates cannot contest is wrong statement because VV Giri independent candidate గానే ఎలక్షన్ కంటెస్ట్ చేసి గెలవడం జరిగింది. So 2, 3, 4 are the answers. So 49C. 50. Which of the following conditions are required to recognize a party as a national party? So all the three conditions are true regarding this straight question. For question number 50, A is the answer. So somebody is asking, but they need support. Support, they may get the support. VV Giri became the president of India while contesting as an independent candidate. So nothing can prevent it. It need not be promoted only by the political parties. Usually, a ruling party proposed candidate will win the election. Opposition party, by namesake, will place a candidate to field a candidate to contest. But usually, ruling party members will win the election. But of course, even the independent candidates can also contest with the support of 50 members, 100 members of electoral college. So if you have any doubts, please raise. So somebody has sent me a mail regarding what action does Election Commission of India requires to when the election contestant dies a day before the polling date. So the question being asked is, if a candidate who is contesting the election, if he dies one day before the election polling date, what will happen? Nothing will happen if the candidate who is contesting is a non-serious candidate and a non-recognized party candidate, not registered, not recognized as a national party or a regional party. అంటే ఇప్పుడు సపోజ్ ఒకరోజు ఎన్నికలకి ఒకరోజు ముందు అభ్యర్థి చనిపోతే ఏం జరుగుతుంది? సో అభ్యర్థి కనుక నాన్ సీరియస్ క్యాండిడేట్ అయితే ఆర్ లేకపోతే ఒక గుర్తింపు పొందిన పార్టీకి చెందినవాడు కాకపోయి ఉంటే ఎటువంటి ప్రమాదం ఉండదు, ఎలక్షన్ కండక్ట్ అవుతుంది. ఇప్పుడు సపోజ్ 2014 ఎలక్షన్స్లో ఆంధ్రప్రదేశ్ నుంచి వైఎస్ఆర్సీపీ తరఫున ఒక లేడీ క్యాండిడేట్ ఒక రోడ్ యాక్సిడెంట్లో చనిపోతే ఎలక్షన్ కండక్ట్ చేయడం జరిగింది. అండ్ కండక్ట్ చేస్తే ఆవిడే గెలిచింది. సో దర్ ఇస్ నో కౌంటర్ మ్యాండింగ్ ఆఫ్ ఎలక్షన్. చనిపోయిన ఆవిడే గెలిచింది. అండ్ అదే రిజిస్టర్డ్ సీరియస్ పార్టీ అనుకోండి, అంటే రిజిస్టర్డ్ పార్టీ నుంచి వెల్ రికగ్నైజ్ నేషనల్ పార్టీ అని రికగ్నైజ్ అయినటువంటి పార్టీ తరపున ఉన్నటువంటి అభ్యర్థి ఆ రకంగా చనిపోవడం జరిగితే ఎలక్షన్ని పోస్ట్పోన్ చేయడం జరుగుతుంది. కౌంటర్ మ్యాండింగ్ ఆఫ్ ఎలక్షన్ విల్ టేక్ ప్లేస్ ఇఫ్ ఎ పర్సన్ who belong to a registered national party is died. Sir, please explain first question. First question ఏముందంటే సిటిజన్షిప్ ఇన్ ఇండియా ఇస్ గవర్న్డ్ బై కాన్స్టిట్యూషన్. అంటే భారతదేశంలో పౌరసత్వం దేని ద్వారా నిర్ణయించబడుతుంది? రాజ్యాంగంలో ఆర్టికల్ 5 to 11 ద్వారా. లా అంటే సిటిజన్షిప్ యాక్ట్ 1955 లా ద్వారా నిర్ణయించబడుతుంది. సో కాబట్టి రెండు కరెక్ట్. ఏ ఇస్ ది ఆన్సర్ ఫర్ క్వశ్చన్ నెంబర్ 1. Election Commission is being inactive these days as the military chief is also involving in the campaigning for election. So, so does the state government has a right to reduce the salaries of their state government employees with respect to Article 360? So the state government has reduced the salaries of the government employees not according to Article 360. అంటే ఈ ఆర్టికల్ 360 ద్వారా కాదు, స్టేట్ గవర్నమెంట్ తన బడ్జెట్ ప్రాబ్లం లోబడి సాలరీస్ తగ్గించడం జరిగింది కానీ ఇక్కడ ఆర్టికల్ 360 ప్రకారం కాదు. And let me know any other question. Sana is asking about, has mailed me a question about removal of Anglo-Indians reservation in the elections. So Anglo-Indians have no reservation in the election. According to Article 331 of the Indian Constitution, Anglo-Indians are nominated by the President to the Lok Sabha. Two Anglo-Indians are nominated to the Lok Sabha. So the President will have a discretion subject to the representation of Anglo-Indians in the Lok Sabha. If there is if they are adequately represented, there is no need for the President to nominate them. So there is nothing constitutionally wrong if the Anglo-Indians are excluded from nomination. So what is the basis for reducing the state salaries? The basis for reducing the state salaries is only budgetary basis. The budget అంటే మీనింగ్ ఏంటి, బడ్జెట్లో మనకి ఎక్స్పెండిచర్ ఉంటుంది, అలాగే రెవెన్యూస్ ఉంటాయి. ఇఫ్ అడిక్వేట్ రెవెన్యూస్ ఆర్ నాట్ అవైలబుల్, అంటే ఇప్పుడు స్టేట్ గవర్నమెంట్కి వచ్చేటటువంటి రెవెన్యూస్ ఐదర్ మన జిఎస్టీ రెవెన్యూ లేదు, లేకపోతే అన్నిటికన్నా ముఖ్యంగా ఈ స్టేట్ ఎక్సైజ్ అంటే లిక్కర్ అమ్మడం వల్ల వచ్చే రెవెన్యూ లేదు. కాబట్టి ఆ రెండు రెవెన్యూలు తగ్గిపోయినాయి కాబట్టి కొద్ది కాలం తాత్కాలికంగా మాత్రమే, టెంపరీగా మాత్రమే తగ్గించారు. ఫ్యూచర్లో ఈ కట్ చేసిన రెవెన్యూస్ని మళ్ళీ అడ్జస్ట్ చేస్తామని చెప్పారు ఆల్రెడీ. కాబట్టి ఇది పర్మనెంట్ కటింగ్ కాదు, అడ్జస్ట్మెంట్ అంతే. కొన్ని రోజుల పాటు, ఒక 2-3 నెలల పాటు అడ్జస్ట్మెంట్ లాగా. సో 45, question number 45 is they're requesting for the explanation. So this question about voter participation in the election process by creating awareness among the voters. So election commission has started celebrating this in process of voter participation in the elections from the year 2009 through what is known as voter education and electoral participation. It is an awareness program about making the voters to vote. So any other questions? If you have, let me know. Sana is asking about right to information also. RTI question will be given in the later test, in the governance test. So focus on these questions, read them, read those questions, and if possible, by heart those questions. Because every question is an answer by itself. So I'm ending the stream here.